Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, having spent most of my adult life in a courtroom, I can tell you that the best quality a judge could ever have, I know many of you would think it would be intellect, and that is a good quality, but you don't find that all the time on the bench. No, it's predictability. I love a predictable judge. Even if you're going to be bad all the time, just be predictably bad so that we can properly prepare for it. And candidly, don't you think that all prosecuting attorneys should be quite the same way? And that goes for the Department of Justice. But every time we start thinking that this Department of Justice truly is a champion of our Second Amendment rights, well, they do something that makes us question it. And what we're going to talk about today is, again, another very schizophrenic, very bipolar move by this particular Department of Justice that has a lot of people worked up. I think the story has been a little misportrayed, so people might be a little more worked up than they need to be, but I'm not saying it's no big deal either. So we'll explain it all here in just a moment. So today, let's spend a few minutes and let's talk about the two faces of this current DOJ. Okay, America, the case we're talking about today involves an issue that has really come to the forefront in the past week or so, primarily due through Department of Justice actions. This deals with the federal ban on 18, 19, and 20-year-olds from possessing and buying certain firearms. We already had to do this video right here about how the DOJ totally screwed up a really good reading in the matter of Reese versus ATF, and now today we're going to have to talk about what's going on in the matter of McCoy versus ATF. This is also a challenge to 18 United States Code Section 922B1, that prohibition on 18, 19, and 20-year-olds that comes out of the Fourth Circuit. Now, this case went to the district court level where the district court found the law unconstitutional. However, the United States Department of Justice appealed it to the Fourth Circuit. The Fourth Circuit overturned that decision. The petitioners now moved to the United States Supreme Court asking to have review granted, and the story broke earlier this week that the United States Department of Justice had filed a brief in opposition to that petition. Is that true? The answer is yes, partially. Now, I'm going to try to get you to understand what DOJ is doing here. I want you to know that they are opposing part of the petition, and on the other part of the petition, they're asking for it to be put on ice. However, the reasonings that they're given, and this is what we're going to focus on today, are mildly disingenuous. Okay, now in this case, there really are two issues that are being litigated. They are, number one, is 18 United States Code Section 922B1 constitutional? That obviously is the issue that we're focusing on, and in that case, the United States Department of Justice is not asking the Supreme Court to reject that petition. What they're asking them to do is to place it on hold for some other cases to be resolved first. The second issue is whether or not the class action was properly certified by the lower court. I'm not even going to bore you with all those details, but yes, the United States Department of Justice is very clearly asking the United States Supreme Court to reject the petition on those grounds. Now, this is what the United States Department of Justice is saying when it comes to this issue about the constitutionality of 922B1. This court should hold the petition for writ of certiorari pending the disposition of Wolford v. Lopez, United States v. Hamani, West Virginia Citizens Defense League versus ATF, and NRA v. Glass. The court should then dispose of the petitions as appropriate. So what the United States Department of Justice is saying is, hey, there's 4 cases kicking around, and we should let these cases resolve because that's going to, in fact, shed light on what the answer should be here. Is that true? Well, let's take a look at each one of the cases. Now, here they are. There's Wolford v. Lopez, United States versus Hamani, West Virginia Citizens Defense League versus ATF, and NRA v. Glass. Wolford v. Lopez, by the way, is the only one of these 4 cases in which the petition has actually been granted. It's the only one we know is going to get in front of the United States Supreme Court. This is what the United States Department of Justice pleads in its brief in opposition. This court recently granted review in Wolford, which presents the question of whether a state may make it unlawful for concealed carry license holders to carry firearms on private property open to the public without the property owner's express authorization. As the government noted in its certiorari stage amicus brief in that case, the court's decision could provide much needed guidance about the proper methodology for applying the Second Amendment. Okay, listen, you guys geek out here with us all the time. So can anyone tell me how a ruling related to Hawaii's vampire law that basically puts a presumption that all private property held open to public is a gun-free zone unless the owner gives express permission otherwise, has anything to do with 18, 19, and 20-year-olds possessing and or purchasing certain firearms? And then the other three cases, these three right here, hey, the United States Supreme Court has not accepted review. And as we know, because we geek out on that stuff all the time too, there is absolutely no guarantee. And with Wolford already being accepted, one Second Amendment case, how many Second Amendment cases do we believe the Supreme Court will take in any one term? Yet the United States Department of Justice still argues. This court is also currently considering the government's petition for a writ of certiorari in Hamani, which presents the question of whether 18 United States Code Section 922G3, the federal statute that prohibits the possession of firearms by unlawful users of controlled substances, violates the Second Amendment. Okay, and again, I'm having a hard time connecting the dots because under 922G3, there is illegal activity that precipitates the unlawful possession. That is, you voluntarily engaging in the use of unlawful substances. 18, 19, and 20-year-olds, last time I checked, have no control over what their age is, and there is certainly nothing illegal about being 18, 19, or 20. Yet, for whatever reason, the United States Department of Justice believes it's important, and here's why. Hamani 2 could provide valuable guidance about the proper resolution of this case. Among other things, Hamani provides an opportunity to clarify the role of post-ratification history in applying the Second Amendment. Or put other terms, the United States Department of Justice is looking for some rule of law that says, well, founding era history is not nearly as important as we may thought, and we could use much more modern history, which we know would benefit every single civilian disarmament piece of legislation in the nation. We then finally get to these two cases, which do in fact deal with the constitutionality of 922B1. So at least we are now in the same ballpark. The reason, though, that the United States Department of Justice believes that those cases should go first is as follows. Finally, this court is currently considering the petitions for writs of certiorari in West Virginia Citizens Defense League, which, like this case, concerns the constitutionality of Section 922B1, and NRA v. Glass, which concerns the constitutionality of a Florida law that bans the sales of firearms to 18 to 20-year-olds. Those cases do not raise the same mootness problems as the case because the lead plaintiffs there are associations suing on behalf of their members. And what they're saying here is the case we're talking about, McCoy versus ATF, who has a couple of other named plaintiffs. Because these cases take so long, the actual named plaintiffs will age out. They will suddenly become 21 while the case is still pending, and therefore the law no longer applies to them. In some instances, they get almost close to retirement age by the time we actually get a final decision on these cases. But ultimately, it leaves the United States Department of Justice to request the following. This court should therefore hold the petition for a writ of certiorari in this case, pending the resolution of the petitions in Wolford, Hamani, West Virginia Citizens Defense League, and NRA. It should then dispose of the petition as appropriate. So the question is the United States Department of Justice vehemently opposing the petition in McCoy versus ATF? The answer is sort of. When it relates to the constitutional issue of 922B1, which we focus on around here more carefully, the answer is no. They're asking for that to be put on ice, let some other cases resolve, and see if that provides guidance. When it comes to the second, more boring issue about the class certification, yeah, they're absolutely positively opposing that portion of the petition. But the reasons that the Department of Justice gives, and the cases that they cite that they believe are going to provide greater guidance, demonstrates that I'm not certain that this particular Department of Justice, as it relates to this issue of 18, 19, and 20-year-olds, is really being intellectually honest with us. And we have to remember that the current Attorney General was a huge proponent of this law being passed in Florida, actually subject to the lawsuit in NRA v. Glass, and has been on the record multiple times promoting these types of laws. So it should not come to us as a big shock if this particular Department of Justice is also hell-bent on upholding similar laws. Listen, we're obviously going to keep our eye on this case, see what the United States Supreme Court does with this case, as well as several others that it has sitting on the doorstep right now. Okay, the case we talked about today is McCoy versus ATF. We're going to link up Department of Justice's memorandum in opposition down below, so you don't have to take our word for it. You can geek out on it for yourself. Now listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.